happens if your ex shows up in court with a signed agreement that supposedly gives them most of the property or changes parenting and support, and you have never seen it before? Many people assume that a judge must accept any agreement that has signatures on it. In Ontario family law, that is not how it works. A court can refuse to enforce an agreement if the court is not satisfied that that agreement is genuine, or if the circumstances around it are legally problematic. This is Nora with Nora Law Professional Corporation in London, Ontario. Nora Law is a boutique firm providing strategic, client-focused legal services in family law, immigration and refugee matters, and corporate governance and regulatory compliance. If this kind of content is helpful, please like the video, subscribe, and turn on notifications so you can stay updated. This video is for legal information. It is not legal advice. Every case depends on its specific facts, documents, and timelines. Now let's get on with this video. Why does this topic matter? Before getting into the law, it helps to understand why agreement disputes become so high stake in family court. Separation agreements are supposed to reduce conflict. However, when an agreement is challenged, it can become the center of the entire case because it can affect property division, support, and the financial stability of both parties. Once an agreement becomes contested, the case often turns on document history and credibility, not just what the agreement says on its face. Now that the importance is clear, the next step is to define what Ontario law treats as domestic contract, because courts often look past the label on the document. In Ontario, a domestic contract is a written agreement between spouses or partners, such as a cohabitation agreement, marriage contract, or separation agreement. Courts care less about the title of the document and more about what the document is trying to do. If a document is meant to govern property or financial outcomes when spouses separate, a court may treat it like domestic contract, even if it is called something else. With that in mind, let us move to a recent example that shows how seriously courts take authenticity and credibility when a disputed document appears. A useful example is the recently decided case of Fazzari and Fazzari. In that case, the parties were in litigation about property issues after separation. Years into that dispute, a document was produced that was said to have been signed before separation. The document was described as a land transfer document, and it claimed that if separation occurs, major properties would be transferred for a nominal amount to a family corporation. One party said the document was not genuine and disputed having signed it. That meant the court had to decide whether the document was authentic and whether it could be relied on at all. The judge's analysis is helpful because it shows the practical approach courts take when an agreement appears and credibility is in dispute. Now that we have the factual setup, the next step is to understand the first question the court usually asks in dispute like this, which is whether the agreement is even real. When an agreement is disputed, courts often deal with it in stages. The first stage is genuineness. The court asks whether the agreement was actually created and signed, when and how the party says it was. If the court is not satisfied that the document is genuine, the court cannot enforce it. In Fazzari, this first stage was central. The judge did not simply accept the document because it looked formal. The judge examined whether the story behind the document held together and whether the evidence supported the claim that it was authentic. So if the court is satisfied that the document is genuine, the court then moves to enforceability. However, before discussing enforceability, it is important to understand how courts test authenticity in the first place. When authenticity is disputed, courts look for practical indicators that the story makes sense. Courts often consider when the document first appeared in the dispute and whether it is reasonable that it was not raised earlier. Courts also look for a paper trail such as drafts, emails, text messages, or lawyer correspondence that shows that the agreement existed at the relevant time. Courts assess whether witnesses tell a consistent story about who drafted the document, where it was signed, who witnessed it, and where it was kept. Courts also consider whether the terms make real-world sense in the context of the relationship and the parties' financial circumstances, because extreme or unusual terms usually require stronger proof that they were truly agreed to. In Fazzari, the court identified significant concerns with the reliability of the evidence supporting the document. The court found that the story behind the document did not hold together in a way that the judge could rely on. And the result was that the document was not accepted as a genuine agreement. So once a judge begins assessing authenticity, the concept that often decides the case is credibility. Credibility is not about who seems more emotional. Credibility is about whether the judge can rely on the evidence. Courts consider whether a witness answers questions directly, whether details shift over time, and whether the documents support the witness's version of events. In Fazzari, the case we've been dealing with, credibility issues were decisive because the court was not satisfied that the document's history and supporting evidence were reliable. When credibility breaks down, a disputed agreement becomes very difficult to enforce. Now that the legal framework is clear, the next step is practical guidance. The advice is different depending on whether you're relying on an agreement or you're facing a surprise agreement. If you want to rely on a separation agreement or other domestic contracts, you should be able to prove where it came from, when it was signed, and how it was kept. You should also ensure that the agreement is clear, specific, and supported by appropriate disclosure and documentation where required. A strong process and a clear paper trail reduce the risk of later challenges. If an agreement appears unexpectedly, the focus shifts from relying on it to testing it. And next, we're going to explain the practical questions to ask immediately. So if an agreement appears late in a dispute, timing matters. You should identify when it was allegedly created, who drafted it, who witnessed it, who had copies, and what communication supports its existence. You should also preserve your own communications and gather evidence about what was actually discussed at the time. Early action matters because it is easier to reconstruct timelines and locate records before documents are lost and memories fade. To close, in Nora Law Professional Corporation, agreement disputes require careful review of evidence, timelines, and the legal standards for genuineness and enforceability. We assist clients by reviewing domestic contracts, drafting separation agreements that are clear and enforceable, and challenging agreements when the evidence does not support them or when legal requirements were not met. The goal is to provide clarity and a practical plan, especially when clients feel blindsided by documents or claims that do not align with their understanding or events. If you're dealing with a disputed agreement in Ontario or you want a properly drafted separation agreement before issues escalate, Nora Law Professional Corporation can help. To book a consultation, please visit noralaw.ca. And if this video was helpful, please like, subscribe, and share. If there is a topic you would like covered next, such as child support, spousal support, parenting plans, or financial disclosure, leave it in the comment. Thank you.